Hi everyone, welcome to Legal Talks by Desi Qanun. I am Suyash and today I will talk about the case of Bhupesh Rathod versus Dayashankar Prasad Chaurasia and Another, wherein the Hon'ble Supreme Court discussed the manner in which a company could institute a complaint under Section 138 of the Negotiable Instruments Act in relation to dishonour of cheque. Before adverting any further, let us understand the relevant provisions of the Negotiable Instruments Act 1881. A. Section 138 of the NI Act provides for the stipulations to be followed in case there is a dishonour of cheque that has been issued for the discharge of a legally enforceable debt or other such liability. B. Section 139 of the NI Act provides that unless the contrary is proved, it shall be presumed that the holder of the cheque received the cheque of the nature referred to in Section 138 for the discharge of liability. C. Section 118 of the NI Act also makes a presumption that a holder of a negotiable instrument is also a holder in due course. Section 9 of the NI Act states that a holder in due course means any person who for consideration becomes the possessor of a negotiable instrument before the amount mentioned in it becomes payable and has no cause to suspect the authenticity of such negotiable instrument. And D. Section 142, subsection 1A of the NI Act provides that the complaint must be made either by the payee or the holder in due course. Section 7 of the NI Act provides that a payee is a person named in the negotiable instrument to whom the money is by the instrument directed to be paid. In order to understand who could institute a complaint on behalf of a company under Section 138 of the NI Act, let us go through the pertinent observations by the court. Firstly, the court observed that if a complaint was made in the name of the company, it is necessary that a natural person represents such juristic person in the court, and the court looks upon the natural person for all practical purposes. Secondly, the court noted that body corporates are de jure complainants, while the human beings are de facto complainants to represent the former in the court proceedings. Thus, no magistrate could insist that the particular person whose statement was taken on oath alone can continue to represent the company till the end of the proceedings. Not only that, even if there was initially no authority, the company can at any stage rectify that defect by sending a competent person. Thirdly, the court also opined that a manager or a managing director, ordinarily by the very nomenclature, can be taken to be the person in charge of the company affairs for its day-to-day management, and usually has the power to take decisions in relation to institution of judicial proceedings before the court. And lastly, based on the above stated understanding of law, the court explained that it would be too technical a view to take to defeat the complaint merely because the body of the complaint does not elaborate upon the authorization. The artificial person, being the company, had to act through a person or an official, which logically would include the chairman or managing director. Only the existence of authorization could be verified. Thus, in conclusion, when a complaint is being instituted by a company, following formalities are important. A natural person represents a company before the court. B. It is the discretion of the company to choose a person of their choice to represent them in the court proceedings. C. The existence of authorization by the company in favor of its representative could be verified by the court. And D. There is no need to elaborate on the authorization of the representative in the complaint itself. Therefore, I hope that the manner in which a company could institute a complaint under Section 138 of the NI Act is clear by now. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.